Hello and welcome back. Right, so we're going to continue looking at the types of behavior that the Equality Act prohibits. So far, we have looked at direct discrimination, indirect discrimination, and harassment. Okay, so today we'll be looking at the last one, which is victimization. Okay, so I'm going to share my screen now, so you can see my slide. Okay, so we have victimization. Okay, so in addition to protecting individuals from discrimination, the Equality Act also protects people from retaliation when they bring claims of discrimination. In previous provisions, victimization, was a form of direct discrimination, which required that a claimant show that he was treated less favorably than someone who did not bring a complaint. Now, remember, in direct discrimination, and I told you, a person needs to show that they have been treated less favorably than another. Okay, so this comparison, made victimization a form of direct discrimination. However, in recent legislation, this comparison has been removed. Okay, so all a claimant needs to show now is that they were subjected to a detriment. Okay, so let's look at the provisions of the Equality Act 2010. Okay, and this is contained in Section 27. Okay, so Section 27 provides for victimization, and it provides that a person, A, victimizes another person, B, if A subjects B to a detriment because B does a protected act, or A believes that B has done or may do a protected act. Okay, and then the section goes on to list what it considers a protected act. Okay, so that's contained in subsection 2. So it says, each of the following is a protected act. The first one, bringing proceedings under this act. So for example, if you file a claim for, say, disability discrimination, okay, disability discrimination is covered under the Equality Act. Okay, so it is a proceeding under the Act. Then it is a protected act. The second one says, giving evidence or information in connection with proceedings under this act. Okay, so for example, someone at work files a claim for, say, for instance, sexual harassment, and then they invite you to court as a witness to give evidence. Okay, that's a protected act. Then the third one says, doing any other thing for the purposes of or in connection with this act. Okay, so anything, for example, you don't actually have to go to court for this. Okay, so it could be raising a grievance procedure because you have been discriminated against, or even seeking more information before you decide to file a claim. Okay, so that's something, for the purpose of or in connection with that, with the act. Okay, so it will be a protected act. And then the last one says, making an allegation, whether or not expressed, that A or another person has contravened this act. So, for example, you could report to HR that you have been discriminated against. Okay, that's an allegation, under the act, and it will be protected. And it is a protected act. Then subsection 3 says, giving false evidence or information or making a false allegation is not a protected act if the evidence or information is given or the allegation is made in bad faith. Okay, so if you know that what you're saying is not true, okay, that evidence or the allegation is not true and you know it, then it is made in bad faith and it will not be a protected act. Okay, so three things are evident, in this section. Okay, so to establish a claim, it is necessary to prove that the claimant has done a protected act, that the defendant was the defendant subjected the claimant to a detriment. And then the detriment was because the claimant did a protected act. All right, so this would also apply, where the defendant believes that the claimant has done or may do a protected act. Therefore, it is not necessary that the victim actually did the protected act, okay, as long as she has been victimized because the defendant thinks that she has done or will do it. This would, will be covered. The provision also covers third parties if they are victimized because they supported the victim, such as, giving evidence in the case. Okay, so just like we did in previous lectures, I would like us to consider some of the words used in detail here. All right, so we have the protected acts. Okay, I have kind of explained it a bit more with examples. But section 27(2)(a), okay, so the first one covers those who brings a claim of discrimination. Okay, so the second one covers those giving evidence or information in connection, with the case. Okay, so I've said the example I gave was, a witness giving evidence. Then the third one covers those doing anything for the purpose of or in connection, with the act. Okay, so I said example, trying to get more information, for the case. All right, so I have a case there, Aziz against Trinity Street Taxis Limited. All right, so it was a taxi driver who owned a taxi, he signed up to a taxi board, the people that send out information that a customer, needed a ride. Okay, so, but at a point, he was not allowed to register more of his taxis, with them. And he sort of thought, that this was discrimination, that they were discriminating against him, but he wasn't sure. Okay, and he was also thinking of, bringing a claim. And he felt, okay, maybe if he talks to the people involved, he may get more information from them and then make a decision. Right. So in the process, he took a recorder with him and made a secret, recording why he spoke to these people. All right. And the Court of Appeal held that a secret recording made by the appellant, okay, so that's Mr. Aziz, to gather evidence in an attempt to establish a claim of discrimination was something done, for the purpose of or in connection with that act, okay, and therefore it falls within the ambit of that law. Then D says an allegation. Sorry, it requires that the claimant makes an allegation that the act has been breached. Okay, so that the Equality Act has been breached. Okay. So whether the claimant was mistaken or not is irrelevant, as long as the allegation was not made in bad faith. Okay, so it says the allegation has to be made, that the act, the Equality Act, or any of the previous discrimination, laws had been breached. In that case, in Waters and Commission of Police of the Metropolis, so the appellant, she was raped by a colleague outside of work, and then she complained, about it and was subjected to a nasty treatment at work, from her colleagues and her superiors. Then she brought a claim for victimization, because she brought, she made that complaint. Now, the problem here was that rape is not actionable under the Equality Act or under at that time was the Sex Discrimination Act. Okay, rape does not come under the Equality Act. Therefore, the act was not breached. Okay, so because the act was not breached, she cannot bring a claim for victimization, and the court, rejected her claim. All right, so you see, whatever the allegation is, it has to come under the Equality Act before a person can be protected, from victimization under it. Okay, so you can bring a claim under another law, and then if they are victimized because they brought that claim, you cannot now establish a victimization under the Equality Act. Okay, so the claim has to be under the Equality Act before you can establish a victimization under the Equality Act. Okay, then the next one says subject to a detriment. Okay, so subsection 1B uses the phrase subject to a detriment. So this replaces the phrase treats less favorably, I said in previous legislation, thereby dispensing with the need for comparison. The aim of the provision is to prevent anything acting as a hindrance to individuals in using the discrimination law. Because if after, imagine after raising a complaint and then a person will be treated badly afterwards. If that happens, then nobody would, raise a complaint in the first place. We have that case in court against Grenada. So in the case, Mrs. Coates sued her employer following her dismissal, for being pregnant. Then after the proceedings were settled, the employer then refused to give her a reference and she sued for victimization. All right, so the ECJ, that's the European Court of Justice, held that ex-workers must be protected from victimization. Otherwise, people will be deterred from, using that law. All right, so with this provision, employers would know that retaliation will not be tolerated. Okay, and as well as remove fears, from employees, from bringing a claim under that law. Okay, and then we have because used in the let me just go back for a second. Okay, so it says a person A victimizes another person B if A subjects B to a detriment because B does a protected act. Okay, right, so the third element of this establishing a victimization claim, centers on subjecting the victim to a detriment because they did a protected act. All right, so this requires that the victim, has to show that there is a link between the protected act and the unfavorable treatment. All right, so it prevents a claim where a victim does a protected act but is subjected to a treatment, for an entirely different reason. Okay, so maybe they brought a claim under the act proceedings or made an allegation, but something else came up where they are, subjected to a detriment. They can't claim victimization because of that. Okay, so there has to be a link between the protected act and the detriment. Okay, so I have a case, just an example of a case for this in Nagarajan against the London Regional Transport. In this case, the tribunal found that the claimant was subjected to a detriment. The claimant was a man of Indian origin. He had in the past brought several claims of racial discrimination against London Regional Transport, his employer. Right, so another position came up within the workplace, and he applied for the job. He was interviewed for the job and was unsuccessful. Then he brought a claim against them, saying that they had victimized him. And then because the interviewers knew about his previous claim, they scored him very low, during the interview, despite him having done that job in the past without having any complaints from the employer. And then the interviewers also considered him anti-management. Okay, so the tribunal ruled that the interviewers were, consciously or unconsciously influenced by his previous claims that he had brought against them. Okay, and then they felt that this was victimization. Okay, so denying him that job. Okay, so that's the detriment. Okay, could be linked to previous claims that he had brought against the employers. Okay, Right, so we have another, so that's it for section 27, okay? We have another section under the Equality Act, which also deals with aspects of victimization. Okay, so we have that in section 39 for employees and applicants. All right, so section 39, subsection 1 and subsection 3. Okay, so subsection 1, I'll just use this. Subsection 1 is the same provision, okay, but subsection 1 deals with talks about discrimination or discriminate. It has the word discriminate, and subsection 3 has the word victimize. Okay, it's exact same provision. Okay, so just these two differences, and the same here as well. Subsection 2 has discriminate, while subsection 4 has victimize. Okay, so section 39, subsection 1 and subsection 3 provides that an employer A must not discriminate or victimize a person B in the arrangements that A makes for deciding to whom to offer employment. Okay, the second one, as to the terms on which A offers B employment, and then the third one, by not offering B employment. Okay, then subsection 2 and 4 says, an employer A must not discriminate or victimize an employee of A's as to B's terms of employment in the way A affords B access, or by not affording B access to opportunities for promotion, transfer, or training, or for any other benefit, facility, or service, by dismissing B, and then the last one, by subjecting B to any other detriment. All right, so subsection 1 and 3 apply to applicants for a job, and subsection 2 and 4 apply to employees, people that are already working within the employment. Okay, so I just kind of broke them down again, just in a bit to explain it better. Okay, so sub A talks about arrangements made for recruitment. All right, so this covers all aspects of a recruitment process. This could be from appointment, even adverts, okay, to the terms of the appointment. This could, it would include, for example, drawing up the job specification, taking up references, and then the short listing processes, okay? So an employer is not allowed to discriminate or victimize an applicant, in any of these processes. Okay, so a discriminatory advertisement can be considered an arrangement made, and a person can bring an action against an employer. Okay, so when an employer is making an advert for a job, they need to avoid sexual or other connotations in the advert. So for instance, if they are looking for a server in a restaurant, okay, so using the word waitress would suggest that they are looking for a man, or the word sales girl would suggest they're looking for a girl. Okay, so they advise to avoid things like that. So you can just use a server or a salesperson. Okay, so but using those would suggest they just want either of them, each gender or sex. Okay, under previous legislation, only the Equality and Human Rights Commission could bring a claim against an employer, for this sort of advert. Okay, so if there's a discriminatory advert and the person is affected, they couldn't bring a claim. Okay, only the Equality and Human Rights Commission could do that. But now, okay, affected individuals can also bring a claim. Okay, so if a job advert discriminates against an individual, they are entitled to bring a claim against the employer advertising for that job. Okay, then we have the terms offered. Okay, so the job offer must not be on discriminatory terms offered. Okay, so for example, a lower pay or a company car, should not be offered just to men. Okay, So if the job is advertised, a man and a woman apply for it, and that job has company pay attached to it, company car attached to it, or any salary attached to it, it can be given to either a man or a woman. Okay, it should not just be reserved for one gender. Otherwise, it will be a discriminatory term. Or, for instance, probationary periods should not be offered to a particular group while it is not offered to others. Okay, so whatever terms that are used that the employer is offering, it has to offer it across the board. Then we'll have a discriminatory dismissal. Okay, so by dismissing B, the subsection would also include constructive dismissal. Okay, so that is an employee. If you remember that from our employment law, constructive dismissal, when an employee resigns because of an employer's breach or actions. Okay, they are the ones resigning, but they can bring a claim for constructive dismissal. All right, so we saw that in Weathersfield Limited against the sergeant in one of the previous lectures, where a white woman was appointed as a receptionist, and then on her first day, she was told not to hire out vans to any colored or Asians, that she could tell them from their voice. Okay, so she resigned a few days later without giving any reason, and then brought a claim for racial discrimination and as well as a constructive dismissal on the grounds of race. Okay, and the defendant was held liable. Okay, then we also have any other detriment. Okay, so this can be found, this is in sub D of that section. Okay, so if the fact does not fall under any of the circumstances specified, okay, such as the dismissal, then a claim may still succeed if the employee, suffered any other detriment. Okay, we have the case Chief Constable of West Yorkshire against Khan. Right, so in the case, the House of Lords held that an employer's refusal to give a reference amounted to a detriment. Okay, so the detriment does not have to be, physical or economic consequences. Okay, so what should be considered is whether the treatment is of a kind a reasonable worker would view that in all circumstances it was to his detriment. Okay, so if it was detrimental to that worker, then it is a detriment under the Act. Okay, an unjustified sense of grievance cannot amount to a detriment. Okay, so just because somebody feels aggrieved, it's not enough to amount to a detriment. Okay, we have a case in Barclays Bank PLC against the Kapoor, number 2. There are two cases on that. Okay, so the number 2 one, the workers that were not given pension rights in respect to their previous services for their employer in Kenya, because the employer had already given them a compensation package, which they accepted. So because they were not worse off financially, the Court of Appeal held that they had not suffered a detriment. Okay, so just because that they were aggrieved at what happened doesn't mean that they had suffered a detriment. Okay, so the Equality Act does not cover third party. I said the Equality Act covers a third party when they are giving a witness evidence, all right, but it does not cover third party victimization where the discriminator victimizes a person connected with the employee. Okay, so say for instance, somebody has brought a claim, okay, against the employer. Okay, so the employer cannot victimize them without getting into trouble. Okay, they would then decide to victimize maybe their friend or their spouse who works with him. Okay, when that happens, the spouse will not have a claim. Okay, because the Act requires that the defendant subjects the claimant himself because the claimant has done a protected act. Okay. Yeah. Okay. So that's it for victimization. It was just a short lecture. Okay. So victimization under the Equality Act is when a person subjects another to a detriment because they have done a protected act. Okay, so this consists of filing a claim, bringing a claim against the employer, for discriminating against the person, a witness, they're giving evidence in the case, making allegations in good faith, or doing any other thing in connection, with the act. Okay, so when any of this is done, and then those will be protected acts. Okay, so if the employer victimizes the person, then they can bring a claim for victimization. All right, so so this brings us to the end of the types of behaviors that are prohibited under the Equality Act. And then next time we will look at discrimination as a human rights issue and under the human rights instrument. All right, so I'll see you soon. Bye.